Hi, Director. It's Chad Clark. I just wanted to preface my video by saying I'm not big into technology, so I'm actually just recording my laptop screen. I hope that's okay. I tried to look for the um, record on the PowerPoint. I couldn't find it. I don't know how to do that. I've never done it, so I'm hoping this works for you. Um, but in Chapter 1, I chose discretion as my first teach back um, item. And so when the police arrest somebody, it's really their discretion whether they arrest somebody, unless it's like a domestic violence situation or, even like a DUI situation where there's bodily injury. I mean, sometimes you just have to arrest people. And once that person is arrested, the prosecuting attorney will decide whether there's enough probable cause to go ahead with the charge of whatever the police charge that person with. And then if they are found guilty, then the judge will sentence them, and they'll sentence them to a whatever they feel is fair and for that crime that they committed. And then the corrections officials in a discretionary situation would be, say they want to put the person who the defendant on work release or what have you. They might be able to go on a work release program. So the corrections officials have some discretion in what they can do with the sentence also. In Chapter 2, mens rea, that's like their state of mind when committing a crime, so purposely, knowingly, recklessly, or negligently. One of those has to be present to have committed the crime. And so they kind of are self-explanatory as far as, if you purposely did something, you had forethought, knowingly did something, maybe not forethought, but you did it knowing that you were going to cause harm to that person, or recklessly, you did it without forethought or knowing that you were doing it, but you were reckless in your actions. And then negligently would be where you did it without intent, but the your actions were negligent. In Chapter 5, for a police career, I chose that topic. So it's usually 21 years of age, a U.S. citizen with a valid driver's license. You fill an application, and usually you're called to do a written and physical agility test. Where the written would be usually 100 questions or so, and then the physical agility test would be a 1.5 mile run, push-ups, sit-ups, what have you. Oral board interview with usually three officers, or usually with a sergeant or above, or maybe even 3 lieutenants who would do an oral board for the candidates. Then you'd be offered a job, and then maybe a background interview the same day that you're offered the job. After that, you could possibly do a polygraph. Some states don't do polygraphs. And then after the polygraph would be a background, or straight to the background after the background interview, where an officer would conduct that. And then medical exam with drug testing. Some states require a previous completion of academy and some firearms training before you can get hired onto a police department, but that's not all states. Chapter 6, some stressors in the job will be external stress, which includes dangerous functions of the job. Going to a guy with a gun, or maybe an armed robbery, or even a burglary where the guy's still or girl's still inside. An organizational stress, which is the inner behind the scenes working in the police department, dealing with the administration, or even lateral movement within the PD, trying to get into detectives, taking the test for that and studying for that, or doing interviews for that. Personal stress could be relationships within the department that you have with one another, or even civilian employees. Some operational stress would be everyday interactions in police work. So, and that could even include the media, where the media might vilify the officers or the department, and that will create stress also, or even the criminal justice system. Some areas of liability in Chapter 7 were approximate cause. So that's if the officer hadn't done this, then this wouldn't have been the outcome. So that the officer caused that to happen. So that'd be an area liability. And person in custody duty of care, where you're responsible for the person that's in your custody. If they fall and break their nose because they were handcuffed and you weren't holding on to them, then you're responsible for that. Failure to protect. So if you had a defendant in your back of your cruiser and you brought him to a call and they ended up getting shot at the call, or you got into an accident, that was a failure to protect that individual, and they weren't seatbelted in and got hurt in that accident. Vehicle pursuit, a violation versus felony. Are you pursuing because it's a violation, and was it worth hitting a family and maybe killing the family when it was just a violation for a stop sign, versus a felony where maybe you're chasing a murderer, and if that guy gets loose, then there could be, he could maybe kill somebody else. In Chapter 8, the exclusionary rule. So that is if you anything that's seized or searched for and found unlawfully, according to the Fourth Amendment, it can't be used in court. So the Supreme Court decisions that came up with that were Weeks v. United States in 1914. That said that federally that couldn't be used in court, but then in Mapp v. Ohio in 1961, it went further and said that even in state courts you can't use evidence that was obtained illegally. And that's it. Thank you.